Members of the jury, you are instructed that in this case the burden of proof rests upon the plaintiff to prove the material allegations of her petition by the fair preponderance of the evidence, and if she has failed to do this, your verdict should be for the defendant. By the fair preponderance of the evidence is not meant necessarily the greater number of witnesses, but it is that proof which satisfies your mind as to its truth when weighed against the evidence received in opposition thereto. There has been introduced the testimony of certain witnesses who purport to be skilled in their line of endeavor. Such witnesses are known in law as expert witnesses. An expert witness is one who is skilled in any certain art, business, or profession, possessed of peculiar knowledge required by study, observation, and practice. You are instructed that you may consider the testimony of these witnesses and give it such weight and value as you think it should have. But the weight and value to be given their testimony is for you to determine. You are not required to surrender your own judgment to that of any person testifying as an expert, or give controlling effect to the opinion of an expert, for the testimony of an expert, like that of any other witness, is to be received by you and given such weight and value as you deem it is entitled to receive. You are instructed that it is the sole province of the jury to form conclusions from expert testimony as to the existence of particular facts, not of common knowledge and peculiar within the knowledge of men, whose experience enables them to speak with authority and to weigh such testimony as given by them to arrive at a decision as to whether the deceased came to his death as a result of a fall or accident, or whether he died from a heart condition. You are instructed that the fact that the deceased had a weakened condition of the heart did not in itself preclude the plaintiff from recovery, and if you find and believe that the evidence that the deceased received a fall which accelerated the condition of the plaintiff to such an extent that death resulted, it was an accidental death within the meaning of this policy. You are instructed that the beneficiary or the plaintiff in this case has filed suit under the double indemnity clause of a life insurance policy which was admittedly issued by the defendant, that under the double indemnity clause upon which this suit is founded, providing that double amount of the face of the policy be paid in case of accidental death, the statement of the person or physician who prepared the proof of death is merely a conclusion of that party and was made only for the purpose of establishing the manner in which he died. You are instructed that if you find and believe from the evidence that the deceased fell, and as a result of that fall he received a severe blow on the head which accelerated or aggravated a diseased condition which was present and had been present for some time, and that death resulted therefrom, it was an accidental death within the meaning of this policy, and your verdict should be for the plaintiff. You are further instructed, however, that if you do not find and believe from the evidence that the deceased fell, and as a result of that fall he received a severe blow on the head, which accelerated or aggravated a diseased condition which was present and had been present for some time, and that death resulted therefrom, it was not an accidental death within the meaning of this policy, and your verdict should be for the defendant. You are instructed that if you find from the evidence in this case by a fair preponderance thereof that Thomas Doolittle came to his death from an occlusion of the heart which resulted directly and independently from all other causes and solely because of a fall which he received, and under the conditions as have been testified to, that the occlusion of the heart and his consequential death was a result unexpected, unforeseen, and involuntary, then it will be your duty to find in favor of the plaintiff and fix her recovery against the defendant in the sum of $600,000 under the double indemnity clause quoted in the policy in controversy. You are the sole judges of the credibility of the witnesses and the weight and value to be given to their testimony. If the testimony of a witness is apparently candid and fair, reasonable within itself, and such witness has been in no way impeached, you should not arbitrarily discard such testimony. It is your duty to reconcile the testimony if you can, so it may all stand. If you cannot reconcile the testimony, then for the purpose of ascertaining what testimony is worthy of credit, you may take into consideration the apparent candor and fairness of a witness, the reasonableness or unreasonableness of his or her story, whether or not the witness has been in any way impeached, the interest of the witness, if any, in the result of the trial, the opportunities or lack of opportunities of the witness to see or hear or know the things about which he testified, whether or not any witness has made contradictory statements, and all the circumstances surrounding the case. If, after a careful consideration of all the evidence in the case, you find that any witness or witnesses have knowingly, willfully, and corruptly testified falsely to any fact material to the issues in the case, you have a right to entirely disregard his or her testimony or any part thereof as you may deem proper. You should consider these instructions as a whole, and you should not reach a verdict based on any single instruction.
What speed was that?
It was...
That indemnity was stripping me out.
So aggravated or exacerbated his condition, I think it was.
That was 185.
Okay. That screwed me up both times you said it.